Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Welcome back to the Business Owners Council, Legal Issues from Growth to Exit. I'm Kevin Rosenquist, and in each episode I sit down with Kevin Brick, founder of Brick Business Law and trusted advisor to Florida companies, to talk through the strategies business owners need to grow, protect, and maximize the value of their businesses. Today we're looking at employment law, an area where even well-run companies can often stumble. From wage disputes to hiring practices, Kevin has seen how small mistakes can turn into costly litigation, and he's here to share how Florida owners can protect both their businesses and their teams. Kevin, welcome back.
Hey, Kevin, good to see you again.
Yeah, you too. So what have you seen in your career? What kind of employment disputes come up most often?
I would say kind of the big categories are like wage and hour type claims. So that's like unpaid overtime, making somebody work off the clock, misclassification, and then wrongful termination, discrimination, retaliatory type claims. And then a big one for us is like non-compete and confidentiality type of disputes. And so I would say those are probably the biggest categories of employment type disputes that come up.
The non-compete one is interesting. There's a lot of talk about that in the employment world, and I understand why. I understand why a business wants to protect their secrets, but also I understand why if someone's trained in a specific area of working like in a certain business in a certain discipline, that it'd be hard for them to really adhere to a non-compete without hurting themselves career-wise. How does the law look at that sort of debate these days?
Yeah, a lot of it actually comes down to what does it say in the agreement that is between the employer and employee. And you're right, it does come up a lot more because there's kind of a blending of personal and business now more so than ever. So you can imagine an employee, maybe they prospect, they do all their prospecting on LinkedIn, right? And then they leave their business and they go somewhere else and they still have all the same contacts. And the employer is saying, well, I was paying you a salary, or I was paying you, in some way to develop all those relationships, and those relationships and the work that's come out of them and all, the benefits of them, they should stay with me as the employer. And the employee is saying, no, all this is because of me. And they want to work with me and they follow me. And so that's kind of how I think the feelings about it go. And a lot of those disputes come up because there is sort of that transferability now of relationships that, wasn't as easy before, where basically somebody would have, the phone number of the business and that's it. That's the only way they work together. And now it's really a lot more tied to the person and their online presence and everything else.
It's a great point. A lot of times we have each other's cell phone numbers and we text in business relationships now. So you're right. It's not, and a lot of times those cell phones are our personal cell phones, not our company phones.
Yeah.
So it does make sense that's getting that line is getting blurred.
Right.
Yeah. So you mentioned wage issues. What kind of wage issues do you see the most, and how do they come about?
Yeah, I mentioned sort of the misclassification issue. A lot of times that's unintentional. Employers think that they're using somebody as a consultant or a contractor, but actually under the law, it's looked at like it's actually an employee relationship. And so the law is pretty, black and white on it. Payroll records, HR compliance, all that stuff has got to be in place. That's the employer's responsibility to make sure they're paying correctly, that they're, not, that they're classifying their employees or others correctly. And so those are the ways I see that come up pretty often. Sometimes a misunderstanding, and every now and then it's, an intentional attempt to save some money on taxes and things. And then, the employer bears the risk of that, if that relationship goes sideways and, they don't have the records, or the records reflect that they did it improperly, then, there's liability there.
Mm-hmm. For fast growing companies, maybe there's a lot of hiring and firing going on, or letting go, or whatever. I mean, there's a lot of moving parts with some of these, especially these days with these tech companies that grow so quickly. How have you seen the hiring and firing practices lead to legal disputes?
Yeah, I mean that you bring up a good point about growing companies, and they are a lot of times there's kind of a war for talent, and they're trying to, you hear a lot of sort of business gurus talk about you want to, fire fast and hire slow. And so I think people are trying to do the right thing by having the right employees in the right seats at their company. So something like firing fast might be good from a management standpoint, but but from a legal standpoint, it's oftentimes that creates liability, right? Because maybe they haven't done the performance records the way they should. They haven't clearly laid out objective standards and show how they weren't met. Maybe they haven't used an employment agreement, or on the hiring side they haven't done a background check. Some of the things that we talked about in prior times is non-compete agreements. They haven't done all those things. And so a lot of times when businesses have a really strong focus on growth, then some of those best practices fall by the wayside of doing things diligently and according to best practices. And that's where they end up finding themselves in trouble, when they're moving too fast and kind of doing things in a sloppy way.
How much weight do things like handbooks and employee agreements and stuff at the front end of a business relationship when you hire somebody? How much do those help in keeping those disputes at bay?
Well, they help a lot. I mean, so basically, a lot of times, when we talk about like the wage and hour type disputes, the employer has the burden of keeping the records and having them, well documented, making sure the right things are in place. And so, if they don't have those, just not having them, creates liability. And then, kind of the question I think you're more asking about is employment agreements and handbooks and all these things that create really the foundational documents of dictating how employees should interact, how managers should lead. Putting those things down on paper and ensuring that everybody's held accountable to it. The best practices have been communicated, to everybody internally, and so that really creates kind of the foundation of saying, if there's a firing decision, here's the line, and here's how they fell beneath it, and making sure that you are not only putting those things in writing, but also regularly enforcing them consistently. Those are ways that employers can really build um, protections legally around employee type claims.
I feel like I've had a lot of jobs where there was handbooks, and I feel like a lot of times they were sort of like, I don't know, people kind of were just like shrug their shoulders, like, yeah, whatever, I don't really care.
Right?
There were
Yeah.
sometimes I got handbooks like 8 months into a job, or someone was like, "You signed the handbook, right?" And I'd be like, "I never even saw the handbook. I don't even know what you're talking
Yeah.
about," and stuff like that. I mean, for businesses who might be fast moving, maybe they don't have a real robust HR department. What do you recommend to make sure that they don't just create these documents, but they actually hand them out and they get them signed and they enforce the rules within them?
Yeah, so you bring up a good point, is that there's having agreements, right? And then there's actually kind of living them within the
Hmm.
the scope of the business, and then enforcing them. So, you know, there's a couple of things to do. You actually have people sign them, so they can't come back and say, "Hey, I never got that." Like, well, you signed
Hmm.
it your first day, So it's hard to say that. And then there's, you have regular trainings or meetings where you reinforce things. I see a lot of employers do kind of like regular trainings, either through videos or other ways where there's kind of a quiz component, where it shows that they understood things that were important. So putting those things in, and I know as an employee, a lot of times you kind of roll your eyes at it and you're like, oh gosh, I got to do that training. But from the employer side of it, you do want to make sure all these best practices, all these protections are not just something that's in a file that nobody ever looks at, right? You want to
Hmm.
make sure they're things that are actually enforced, and that people know about them and they know what the expectations are. And a lot of times too, you know, reviews that are written where we call out things that are best practices that are written down. Are you following it or are you not? So you have these records of reminding people or telling them what they should be doing. all those things are very important. And you mentioned, how do these companies that they don't have a HR director, how do they do it? Well, having just an outside general counsel, somebody that you can go to, kind of regularly talk about things that come up, having those meetings, getting that guidance, and then kind of having a cadence of enforcing it. I think those are some good ways that you can, kind of split down in between having like the cost of an HR director, where you can't maybe afford that, but you can afford a couple hours a month of your outside counsel's time to make sure you're doing that right.
A lot of times businesses want to, if they want to get rid of somebody, they might, look for a good reason or try to find, not manufacture necessarily, but like if they're just like, this person's not a good fit, maybe they point to something in the handbook that they're not doing right. But you have to be consistent, right? If you lack consistency in how you discipline based on the handbook, if you're not consistent with it, can that open the door to litigation?
That is an argument that's often made, where you got to think of that plaintiff's attorney that's representing the employee that's saying, yeah, there's a policy of, let's just say, non-discrimination, right? It's written down, but look at, the actual hiring practices. Look how it's actually enforced. And so if somebody like, or just even a simpler example, if there is a time where everybody's got to be at work, that's a policy, but only one person is getting written up for being late and nobody else is, that selective enforcement, that ends up being, everybody understands what that is. You're targeting one person. So you got to
Mm-hmm.
be not just, consistent with enforcing it, but enforcing it the same way with everybody,
Mm-hmm.
and so that is something that sometimes it's tough to monitor, but making sure that that's done regularly and consistently and applies to everybody the same way is an important part of reducing claim exposure.
Mm-hmm. I can imagine. Okay, so if an employment claim is filed, what immediate steps should a Florida business take to protect itself?
Well, if they have an attorney, obviously notify their attorney. One of the things that the attorney is probably going to do is going to ask them to start preserving all of their records that are related to it. They may do an investigation internally of what happened. A big, a big sort of no-no is when there is a claim. A lot of employees or owners, like, they start sort of gossiping about it, and they might, they text or they Slack or they email, and all of a sudden they've created like a bigger problem, maybe with the way they've responded to it. So keeping internal discussions limited and professional when they have to happen. Your discussion, the employer's discussion with their attorney is confidential, but the discussions with the employees and others internally, that's not confidential. So that can become evidence in a case. So that's an area to make sure you're getting good guidance on before there's, a lot of talking about what happens. Attorneys will cooperate. Generally, I think it's a best practice when a claim comes in to cooperate with opposing counsel, not ignore it, but do so in a strategic way. Acknowledge the claim, an investigation, or whatever those steps are being taken, so that it can be addressed proactively. I think those are some of the things you'd see when a claim does come in, to make sure that everything is kind of being orchestrated to move in the right direction, to ensure that something doesn't become worse than it is.
A lot of times it depends on what state you're in, but there's a decent amount of states that it's sort of like it heavily favors the employee over the business, and business owners struggle with that a lot of times. I know of someone who went through something like that in California, and they just felt like they had no rights whatsoever as a business owner. How does that work in Florida? In Florida law, do you feel like it's pretty even as far as the businesses and the employees, as far as how the rights that are given and the chance that they have to defend themselves?
I would say Florida is more pro employer side.
Mm-hmm.
It's a state where the employer, can basically dictate the terms and follow them. Obviously all the federal protections exist about harassment and discrimination and all those
Sure.
things, but overall, I think Florida is more a little more pro-employer, certainly than a California, but a lot of other states. So essentially, the businesses here in Florida, I think, are in good shape to be able to protect themselves as long as they're good actors, as long as they're doing what's right, they're reasonable, they're responding appropriately, and the things we've talked about, they follow kind of best practices. I think Florida-based employers should be in good shape to protect against those kind of claims.
Are these generally settled? Do they ever really go to trial?
They do. I mean, I'd say they follow the pattern of litigation in general, where if like both sides seem to think they've got a really good position, then those are the cases that get to court. A lot of times with employment-based claims, there's insurance at play. So insurance companies do a good job of coming to the table and trying to settle. And generally, I think they're successful at that. You see statistics out there, and I don't know offhand, but 90+% of cases probably do settle before trial.
Mm-hmm.
And I'd say that's probably pretty consistent in the employment side as well.
Mm-hmm. Obviously you can't predict everything. Some people, some things happen. Some people are perhaps looking for a case or just, you have some bad actors, whatever you have. But what would you say are the best ways a business owner can protect themselves proactively from any of these types of things happening?
Yeah, I mean, I would kind of refer back to a couple of the things that we've hit on big picture, having essentially, employment agreements from the outset, doing a background check, and following up on references, making sure that the people that you're hiring are who they say they are, making sure that your team understands all of your employment policies, updating those regularly with your outside general counsel, making sure they're enforced, that people are being trained. And then when those, decisions come up where you have to terminate somebody or go separate ways, or, even demotions internally, passing people over, sometimes those create issues as well. Make sure you have trusted outside counsel to talk to about those decisions before you do them, right? So you're putting pieces in place that essentially are protecting the business before making those things, so you're doing things that are prescriptive rather than reactive. And you can't avoid every single problem.
Right.
You can just do your best to minimize it. I think if you're running a business, if you own a business, then you have some risk exposure. You might be a target of those people that you're talking about, and you could do all the best things and still, you find yourself with a problem that you didn't create or you didn't cause, but sometimes it just came to your doorstep and you got to deal with it. And so if you do all those protectionary things kind of, I think, on the front end, then hopefully you'll be in good shape to deal with any sort of claim that comes up from bad actors or bad situations.
Yeah. I think that's great advice. All right. Well, that's it for today's episode of the Business Owners Council with Kevin Brick. Employment issues, they can disrupt any business, but with the right policies and proactive advice, owners can protect their companies and avoid costly disputes. To learn more about how Kevin and his team at Brick Business Law help Florida businesses with employment matters, visit brickbusinesslaw.com. Don't forget to subscribe to our channel and leave us a review. We got lots more great stuff coming your way. Thanks, Kevin. Really appreciate your time.
Yeah, thank Kevin. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.